thousands await resolution, Labour government acts on Rwanda deportation scheme fallout. The shadow of the now-defunct Rwanda deportation scheme continues to cast a long shadow over the lives of thousands of asylum seekers. Initially touted as a solution to the UK's asylum backlog, the plan, which saw the UK government agreeing to send asylum seekers to Rwanda for processing, was met with widespread condemnation from human rights organizations and legal experts alike. The scheme, which ultimately cost UK taxpayers a significant sum, never successfully removed a single asylum seeker. However, it left thousands languishing in a state of precarious uncertainty, their futures hanging in the balance. Now, under the newly installed Labour government, a significant step towards resolving this humanitarian crisis is underway. The swift action taken by the Labour administration to scrap the Rwanda plan marks a clear departure from the previous government's policy. The decision not only reflects a commitment to upholding human rights, but also acknowledges the significant logistical and ethical failings of the scheme. With the Rwanda agreement officially terminated, the immediate concern shifted to the fate of the approximately 5,700 individuals whose asylum claims were effectively paused pending deportation to Rwanda. While some individuals did receive a resolution to their cases following the scheme's cancellation, a significant number, thousands, in fact, remained trapped in a state of legal limbo, their applications neither processed nor rejected. This uncertainty created immense stress and anxiety, with many experiencing prolonged periods of hardship and displacement. The plight of these asylum seekers was further exacerbated by persistent rumors and speculation regarding potential alternative deportation destinations. Whispers of government discussions concerning the establishment of return hubs in various countries, including several in the Balkans, fueled anxieties and instilled a deep sense of fear and insecurity amongst those affected. The uncertainty surrounding their futures created a climate of apprehension, leaving many vulnerable to exploitation and further displacement. The threat of being moved to other countries, often with less robust human rights protections, loomed large, casting a dark cloud over their already precarious circumstances. These fears manifested into tangible action when legal challenges were initiated on behalf of these individuals, with a critical court hearing scheduled to take place. This legal action aimed to provide a mechanism for redress and ensure that the rights of the affected asylum seekers were upheld. The weight of the legal challenge underscored the urgent need for a definitive resolution, highlighting the failure of the previous administration to address the humanitarian crisis it had created. This impending legal showdown put the government's handling of the asylum backlog under intense scrutiny. Just hours before this crucial court hearing was set to commence, however, a significant development unfolded. The Home Office released new guidance, dramatically shifting the landscape of the situation. This guidance unequivocally stated the government's commitment to a substantive review of each individual asylum claim. It effectively declared that the inadmissibility actions taken against the affected asylum seekers under the Rwanda scheme were being discontinued. This decisive action, taken at the 11th hour, averted a potentially protracted and costly legal battle, while simultaneously demonstrating a commitment to addressing the humanitarian concerns at the heart of the issue. A spokesperson for the Home Office emphasized the government's position, stating, "The Home Secretary has been clear that the costly migration and economic development partnership with Rwanda wasted taxpayer money and should not continue." This statement underscores the government's acknowledgement of the financial burden and ethical failures of the previous administration's policy. It also signifies a commitment to rectifying the situation and ensuring a fair and just process for those affected. The focus has now shifted from deportation to a comprehensive and fair evaluation of each individual's asylum claim, acknowledging the human cost of the previous government's policies. This sudden shift in approach signifies a significant victory for the asylum seekers and the human rights organizations supporting them. It also reflects a positive change in the government's commitment to safeguarding the well-being of vulnerable individuals seeking refuge in the UK. The expedited processing of asylum claims will hopefully bring much-needed relief and certainty to the lives of those who have endured prolonged uncertainty. However, the situation remains complex. The sheer number of individuals affected, combined with the inherent complexities of asylum claim processing, means that a swift resolution for everyone will not be immediate. The new guidance sets a crucial precedent for future policy decisions relating to asylum seekers, emphasizing the need for humane and legally sound approaches. The Labour government's actions serve as a stark contrast to its predecessor's policies, highlighting the importance of ethical and effective asylum processing within the context of human rights and international law. The road ahead remains challenging, but this decisive step towards justice offers a beacon of hope for the thousands of asylum seekers left in limbo by the failed Rwanda scheme. The case serves as a crucial reminder of the urgent need for a comprehensive and compassionate approach to asylum claims, ensuring the protection of vulnerable individuals while adhering to the highest standards of human rights. The journey toward a just resolution may still be long, but this pivotal change signals a hopeful new chapter.